You all heard about the McDonald's case. The woman poured hot coffee on herself in the car in the drive-thru and sued McDonald's. Even though that verdict ended up being greatly reduced, she did not, in fact, get $1 million for coffee spilling on her. It was still a several-month trial with legal fees up the wazoo. Did you hear about the SeaWorld case? This was a man who his lifelong fantasy was to swim with whales. So he hung around at SeaWorld after closing time and hid in a bush or something and went into the killer whale tank. And what happened? He got killed. and his family sued SeaWorld. And the substance of the lawsuit was, yes, there were warning signs, killer whales, but they failed, in the plaintiff's opinion, to notify the person that they can kill you. So it was too general. And then there was a Kentucky man this past year who was very shy and wasn't really sociable in his office. And his birthday was coming around. And he went to his supervisor and begged the supervisor, please don't let anyone do like a little party for me in the office break room. Now, those of you who have had office jobs, is there anything more terrible than the little office birthday party? It's just the Entenmann's cake that someone, grabbed on their way into the office. Well, the office manager was undeterred and thought, everyone likes a little birthday party. So they proceeded to serenade him with the candles and the cake in the break room, and he had a panic attack. And he was just so mortified with the attention on him that he left the office, went out into his car for 2 hours, and he was just paralyzed. Needless to say, when he came back into work, everyone was kind of laughing and snickering. He ended up suing the company for $540,000, and he won, and he got to keep that. So, we need to be careful today. We're living in a gotcha society all the way around. And it's a little bit ironic. I've shared this anecdote before. My late grandmother was a trip and fall queen. She would, at a family wedding, if there was an open bar and an open dance floor, a few drinks in, she would go into her charo moves, and that often ended in a fall. Does anyone remember the Amber Lantern? That went out of business after one of her lawsuits, yeah. So I think it's kind of ironic that I help people now keep their assets safe. She was also a little bit of a kleptomaniac. She blamed that on the Great Depression and beefsteak Charlies. Does anyone remember that? So she would go to the all-you-can-eat shrimp, and she'd be prepared with her supermarket plastic bag, and she'd put the shrimp in the plastic bag in her pocketbook. And when it went out of business, she was so sad, and I said it was your fault that they went out of business. Now, John, how long do we know each other?
30 years.
Yeah, okay. So John is the best person in the United States, and I've never told you this. My grandmother stole from you. It was a family funeral, and she went to the ladies' room, and she was gone a long time. So my sister and I thought that maybe she's very upset, and we went to check on her. And this was at your Flushing location. She was in an upstairs office swiping pens, calendars, and I went in her bag and I took out a lot, but she would not let me return to you your tape dispenser. So with that as the backdrop, it's just, in my opinion, bananas to own real estate in our own names today. Nothing is off limits. You can have an Amazon worker trip and fall on your steps, and if the real estate is in your name, they will sue you. And nothing's a secret anymore. You know, you remember growing up, the deed to the house was, you know, locked in a tin box and hidden somewhere in the coat closet. Today, we can all punch in an address and bingo, we learn who owns it, when they bought it, what's going on. There's no privacy and there's tons of liability. So what do we want to do with the house to protect it from ordinary slip and fall liability and to protect it from long-term care claims? Okay, that's what we're going to start today with, long-term care. Almost everyone who is over 65 has Medicare, and you have a Medicare supplement, which do a beautiful job of covering the acute phase of an illness. When I go to the hospital, Medicare and the supplement pretty much cover everything. But when we leave the hospital, where do we go? We go to rehab, because today the hospitals get paid based on what I have, not how many days I was in that hospital bed. So it behooves them to get us all out quicker and sicker, and we're in no shape to come home, so we go to rehab. And rehab is the front door to a nursing home, because Medicare and the Medicare supplement, does anyone know how much it covers? Should all have a will. Everyone in here should have a will. But the goal is not to have to use it, because the will goes to probate. And we want to avoid, you know, New York state law says that a probate must be open for a minimum period of 7 months. I am practicing for over 20 years. I've never seen a probate go as quickly as 7 months. Okay, you're looking at much longer, and who is going to pony up the money for the utilities so the pipes don't burst, and who's paying the property taxes? It's a recipe for disaster. And that is where your beneficiaries get along. If there is any complexity, if there's a second marriage and, you know, we have a blended family, you need to avoid probate, because the will can be pretty easily challenged. And even if the will ends up being legit at the end of the day, did you really want to spend 2 years in court with a will contest? So we are, in my office, and I'm going to put him on the spot, we have Dominic Esposito, an associate attorney in my office, who handles a lot of the probates. I have been in the situation where I tell a lovely client, just offer her $20,000 to go away, or we're going to be in court for the next 2 years. And that's a painful conversation to have. But at the end of the day, they're financially better off. If you have a screwball in your lives and you think that they may institute a challenge later, you need to avoid probate. You need to have a trust where everything goes directly. Okay, so the very long wind up to the answer to the question, who determines that the trust is legit? Well, the trust does not have notification requirements. So in the trust, If I name the 3 children I'm talking to and not the one that I'm estranged from, no one knows where he is, they don't have to notify him where they would with the probate of a will. But let's say some disgruntled person, if my daughter needs more money and I gave her 40% and I gave the other 2 30%, and someone challenges that, saying she didn't have all of her marbles, was the capacity of the person in question. That is fodder for a challenge. The legitimacy of the trust would come up, let's say, in a title situation. So my adult children are the beneficiaries. The trust says they get everything even Steven. They go to sell the property. The buyer's attorney is going to want to have title insurance, and they look at the trust, and the attorney for the title company may say, this is a lemon. They didn't even effectively transfer the property into it. And I've seen this in the context of these mail order kits. There are financial professionals out there on QVC selling these kits, and you get the kit, you fill it out, but you forgot to transfer the deed into the trust. So, it was a wasted $49. So the trust is presumed legit unless there is a challenge to it. There is no general. There is no general. It is all over the place, and with everything in life, you want to be somewhere in the middle. Do you need a lawyer to do all of these things? No. No. You don't need a lawyer to do a healthcare proxy, right? I'm outraged when people charge for a healthcare proxy. I was a co-sponsor of New York State's healthcare proxy law in the 90s, and one of the features of our healthcare proxy law is it's do it yourself, right? On my website, I have a little area of do it yourself documents. Download the healthcare proxy, fill it out. The only room for error with a healthcare proxy is we cannot name 2 people to be co-agents. You can have co-agents everywhere else in your legal life, on your power of attorney, on your trust, co-executors of the will. You can't have co-agents on the healthcare proxy. It's as if you have no healthcare proxy. So do that, and you're going to feel a little bit more in control, right? A living will. I don't even think you need a lawyer for a living will. That's where I set out my wishes with respect to health care. On my website, I have my own living will, and it says, and I recommend that everyone who agrees with this, put this in your living will, in the event that I require care, I wish for the care to be provided in my home unless it's not possible. Put that out there as a default so that your team, whether it's family or whether it's a team that you've assembled of outsiders, so to speak, a geriatric care manager, an attorney you work with, the people together will follow your blueprint to make sure that your future looks the way that you want it to look. What is the number 2 fear? The number 2 fear is aging. And a lot of it, I believe, is because we don't know what that's going to look like. I don't want to be dependent upon other people. So we need to, take the bull by the horns and way in advance of a problem, cobble together what our future care looks like. And I think about putting the foods that I like in the living will. What if I, lose my memory? I'm still going to like pizza, right? So let me put instructions in there for the future care and feeding of Anne. Yes?
a rental. And if I want to sell it now before I die, how gonna be with the capital gain taxes?
Okay, so
I still have, you know.
yeah, so with this trust, it's a grantor trust, meaning under the Internal Revenue Code, it is a disregarded entity. It doesn't help you, it doesn't hurt you. So during your life, with a properly drafted trust, which I believe you have, you get all of the rental income. It's been business as usual. If you sell the property, you will have long-term capital gains. The only capital gains magic occurs when the properties pass at death to the next generation, then they get that elimination of all capital gains. But with the trust, if you wanted to do a 1031 exchange, you're still able to do that. Yeah.
You might have said this. To get federal benefits, can you put it in a revocable trust, or does it have to be an irrevocable trust?
Okay, so the question is revocable or irrevocable, and the answer is no. we want to be somewhere in the middle. It's bananas to do a purely irrevocable trust. A revocable trust is as good as water, when it comes to asset protection. You simply don't have any. If I have a revocable trust, the nursing home will say, okay, go revoke it and sell the property, pay for your own care, and when you're down to exhaust fumes, then we'll put you on the program. Yes?
Can annuities and life insurance policies be protected under a trust?
So can annuities and life insurance go into the trust? Like I said earlier, we start with the real estate. In my opinion, the real estate is a no-brainer. If the trust is properly drafted, you will not feel the difference. You're going to continue to pay the taxes, the insurance, no money is going in there. The next asset class that makes a lot of sense to me to put in the trust is life insurance with a cash value. If you have a term policy that has zero cash value, that's not going to be a countable asset for Medicaid or other program benefits. So if you have a term policy, leave it alone. Make sure that your beneficiaries are up to snuff. If you have a policy with a cash value, I am the measured life, you are the beneficiary, I am the owner. We're simply going to change the ownership from me to this trust. The annuity, it depends on whether it's a retirement annuity, in which case I would not put it in, you don't need to. If it's a normal investment annuity and you're beyond that first 7 years of a transfer penalty, then that's something to consider. Andriana, do we have Zoom questions? Co-ops, as you know, co-ops are not real estate. They're shares of stock, just like Con Ed or GE. And the boards are challenging to deal with. That's a euphemism. And the co-ops that allow trust ownership, roughly 50% in my experience, will make you stand on your head with their full application process and go through months with their attorney who wants a few $1,000s to review the trust that they have reviewed dozens and dozens of times, but they need some money to review it again, okay, and then they transfer the shares into the trust. For people with a co-op that does not recognize trust ownership, we get a little more creative. If the bylaws require your co-op to be owner-occupied, which is very common for the one half of the co-ops that don't allow trust ownership, we can often negotiate with the attorney for the board to have one of the shares in my name and put 99% in the trust. That's something we've done. But the go-to thing that we do in my office, and this is going to make no sense, it's called a limited assignment. And with an assignment document, I transfer my future economic interest, a pertinent connected to the shares of stock. I'm pushing away my dollar interest. And in this assignment document, it says, Ann Margaret Carosa continues to view the apartment as her home, and if upon her death anyone is in the premises, they must vacate within 30 days unless they are approved by the board, normal process. This assignment of the economic interest is binding on New York State's Medicaid program. So if you're in a co-op that doesn't allow trust ownership, do this assignment and you're protecting the asset for the benefit of the children.
And the second one was, my son lives with me and wants me to change my will so he gets the house. This is all I have currently, and he says he'll share all three with the...
Okay, so when we have a child who needs more than the others, when we have a child who's living with us, we need to think about how are we going to avoid World War III for these kids down the road. If he's been living in the house since his divorce 15 years ago, I think is unfair to expect him, to pack up and go within 30 days. It's also unfair to the others, if that's the only asset, to say they can't sell it until he's deceased. So you want to be creative, and you can say that the property goes 3 ways, subject to Tony's right to occupy the property for a period of, and you fill in the blank. Okay, give him an opportunity to get himself together. Maybe that's 6 months, maybe it's 2 years. And you say during this right of occupancy, Tony is responsible for the upkeep, the utilities, the carrying costs, on and on and on. At the end of the right of occupancy, then give him the right of first refusal to purchase the interests from the other 2. So, cobble together something that's fair. And this right of occupancy is also a nifty device when we have a second marriage. If my new younger husband is badgering me to put his name on the deed to the house, and if it's in the trust, I'm not going to be able to do that because we've blocked his ability to be an owner. But in a vacuum, I can say that he has the right to continue to be there upon my death if we were still together as of the date of my death. He can remain there, I don't want to say for life, because I have seen clients have nightmare scenarios where the new spouse is able to be there for life. The kids can't even get in to get their baby pictures. He deadbolts the doors, and if he moves to Florida, he's allowed to rent out the house and he gets the rental income. So never say it goes to the new spouse for life and then it reverts to the kids. Say they have a right of occupancy until the earlier of his death, his voluntary departure, 2 years from my death, or his cohabitation with an unrelated person who is not a caregiver, right? I don't want him bringing his new special friend into my house. Let them go to her house. So, all of these situations should require us to view the planning with a little creativity and a little common sense. At office for the first appointment, I tell them, bring your existing documents. Sometimes the documents are good, and sometimes the documents are not good. And the illustration that I shared in my first book is an attorney who I am social friends with in Queens. That's as far as I will narrow it down. He's a personal injury attorney, and a few years ago, he asked me to look at a trust that he was drafting for someone. And I thought it was so odd that he was drafting a trust for someone, but I take the trust home with me, and frustrated school teacher that I am, I have my red marker, and a few pages in, this thing is the legal equivalent of like a Freddy Krueger movie. It was crazy. He's referring to provisions of the Internal Revenue Code that were repealed decades ago. And it was immediately clear that he got a hold of some retired or more likely deceased attorney's files, had his secretary, cut and paste the names. It looked like a fine document, but it was a pile of rubble. So now I'm having this Dear Abby quandary. I didn't want to hurt his feelings and tell him it's horrible, so I called him Monday, and I said to him, in order to evaluate the trust, I need to know more about the client. Now, should he have shared any intel with me about his client? No, but 30 minutes later, in my fax machine was social security numbers, brokerage accounts, on and on and on, the confidential intake questionnaire of this client. So I cobbled together something that was a lot better, and I was still, afraid to hurt his feelings. I said, well, I made some changes. Now, there wasn't like a semicolon left from what he had. And you know what he said? He said, well, I'm glad I was on the right track. Now, and the scary thing is this guy has a shingle out that says elder law because he has one Ann Margaret Carosa trust from the year of the flood, which I'm not even using this trust anymore. So it's Russian roulette, which goes back to my earlier comments. No matter how great your attorney is, you need to be a party to it. What does this mean? What does that mean? Where does it say that I have all of the ownership rights? Where, on and on and on. So glad you asked this question. The single most important piece of advice that I can share with you, that it's going to sound like common sense, but when we're in the orbit, when we're in the eye of the storm with a loved one and healthcare issues, our brains remain in the parking lot. And we're asked by a lovely social worker to sign these papers for mom. Don't, okay? Because you can unwittingly undertake a third-party guarantee to cover the cost of care. Those of you who have adult children, tell them, don't sign this paperwork. And when you sign paperwork as an adult child for a parent, I'm going to write, I'm going to sign Ann Margaret Carosa, comma, P-O-A for Candy Carosa, my mother. Yeah, so that is how, you best protect yourself. We're not avoiding the 5-year look back, we're getting it started, right? You want to get that under your belt. So the way that it works, I do my trust, I transfer the property into the trust. It needs to be baking in there for 5 years before it's totally invisible, but you get partial credit. If I put my house in the trust today and we make 4 years before I fall apart, now I only have to privately pay that $16,000 a month for that last year. We're trying to get to the other side of the divide. Now, the question was, is this hybrid type of trust off limits to Medicaid? Yes, it is. And we go back to if it's properly drafted. You could have something that's garbage. Just because what we call it doesn't matter, okay? The thing that matters is all of the legal bits and pieces in it. Now, by way of background, in the legislature, I chaired the trust task force and was involved in the creation, development, amendment of New York State trust laws. Okay, I can't park a bicycle and you don't want me cooking a meal, but with the trust, I am happy to look at any trust that someone has and tell you right away, yay or nay. But better to start at the outset with a good trust where you retain a set of handcuff keys to make any changes that you think you may need to make later on. If you have real estate, Part A is creating the trust. Part B is changing the deed into the trust. Does anyone have an LLC or an LLP or an S Corp that owns real estate? The real estate would remain in that limited liability entity, so you wouldn't have to change the deed for property in an LLC. The LLC protects you from ordinary trip and fall liability. The LLC alone does not protect that asset from healthcare claims, and the LLC alone does not avoid probate. So if you have that limited liability entity that owns your investment property, we need to recapitalize it to issue new membership units or shares of stock, as the case may be, into the trust. Now you have a beautiful situation like Russian nesting dolls. You have the real estate that's owned by the LLC, and now the LLC is owned by the trust. It's lovely, yes. Do you have control over the property in the trust? What if you need to take financing from it? The bank will likely tell you, yes, we can do it, but with the trust, your rate is going to be a little bit higher. So your option at that point would be to temporarily pull it out of the trust. And we can do that if the trust is properly drafted. Then the grantor and the three beneficiaries signing together can temporarily pull that property out, put it back in mama's name. I do the reverse mortgage or the HELOC or whatever the financing is, and then I throw it back in the trust with that monkey on its back in terms of the mortgage. And a reverse mortgage, I have no horse in the game. I don't do them professionally, but I will tell you, don't be, knee-jerk against them. It can be a lifeline. And I had a client that illustrates this. She was the widow of a physician living in a beautiful to-die-for house, and she had no money in the bank. And the traditional advice was, okay, Louise, you need to sell the house and downsize. She loved her house. She took out a reverse mortgage for $300,000. The property at that time was worth about $1 million. And with the $300,000, she enjoyed her last days. She still got a car every couple of months to take her into Manhattan and go to the opera. She lived in her beautiful surroundings. And at the end of the day, yes, the reverse mortgage people were at the table when it came time to sell, but I don't know that the family was really any worse off because she continued to get the fair market value appreciation on the entire home. So did it increase by $300,000 over the course of those years? I think it did. So at the end of the day, her kids weren't even in a worse situation. And she was happy, and that was, the number one thing. Before we go to any last questions, I do want to piggyback on what John Golden was talking about with the pre-planning. Now, I have a little bit of a peculiar profession in that I'm dealing with grieving adult children on a very regular basis. And the adult children of people who have the foresight and generosity of spirit to pre-plan their funerals, it is like the final gift that we're giving our kids as parents, to save them from, making poor decisions while they're grief-stricken. And, I have made some very poor funeral decisions while grief-stricken, and it's just a lovely thing to do. If we can summon the courage to sit down with John and the wonderful team, Anna and Vincent, they are the best. And he alluded to this in his remarks. We all have this little psychological attachment to the funeral home where our parents and our grandparents went. But they're all different now because they all sold to national chains. Gleason's is family owned, and the difference is really apparent in the eye of the storm when you're working with them. They do treat everyone like family, and they're really great neighbors and a resource for the community. So I thank Gleason's for everything that you do for the community and putting together a program like this. It's not all doom and gloom. Has anyone read or you've heard of Stephen Covey's 7 Habits of Highly Effective People? He has a chapter, Begin with the End in Mind. And if we can roll up our sleeves and deal with some of these issues, at the very least, sit down with the folks at Gleason's. What does this all look like? Make some, preliminary thoughts and deal with the issues that I'm talking about so the kids are insulated from conflict between themselves. And, we rewind to our first chapter as parents when we're decorating the nursery and picking out the bassinet items. Everything was custom, it was creative. Yet on the other end of the rainbow, our last words to our children, and that's what last will and testament is, Greek for my last statement and wishes, we wing it and we say, okay, everything 3 ways to Mary, Susie, and Johnny, good luck, without really how can I give them a soft landing and insulate them from taxes, from fighting with each other, and from the claw of the Medicaid program looking to take the real estate. So it's our last parenting chapter, all of these issues. Does that make sense? Okay, that's a great question. Are these legal documents state specific? So the trust, that should really be the linchpin of all of our legal planning, that is a creature of the Internal Revenue Code. It's federal in nature. You don't need to change it. You would sell the New York property, and on the day of that sale, they're going to give you a check payable to the trust, and on that day before your celebration dinner, you'll swing by a bank and maybe for the first time open an account in the name of the trust to negotiate that check. And now with that checkbook, you'll buy your new condo in Arizona, and you didn't break the spell of this 5-year clock. If we move to another state, I would want to update the little documents. I want the healthcare proxy to be the one that they're used to seeing in St. Petersburg, right? But the big stuff is not state specific. again, a normal brokerage account, I wouldn't be gung-ho to put that in the trust unless there was a reason to do so. You have a joint brokerage account. If Mary gets sick, then John needs to go to the broker with a power of attorney and say, transfer the joint account into my name alone. The 5-year look-back does not apply between spouses, okay? So we can kick the can down the road a little bit with respect to the money and non-retirement brokerage assets. With the mental game plan, if we're part of a married couple, we're going to transfer that account between ourselves if someone gets sick. What if both of them get sick and John and Mary have this big joint brokerage account? Then I would tell their backup agent on the power of attorney, now transfer it into the Jones Family Trust. We like the investment mix. It's not a liquidation event. We're simply going to put the account in there. It has a new title. And under current law, we'll end with a piece of good news, there is still no look-back period in New York State for community Medicaid. So if John and Mary need someone to come in the house and help them, they would be well advised to put their countable assets, most of them, in this trust that hopefully already exists. And then we can apply for community Medicaid to cover what Medicare and the supplement don't cover.
Yeah, but does it get renamed?
I said it did. It's now Jones Family Trust. It gets renamed, but not reconfigured. You're not selling the positions. Okay, transferring money from a 401k or another retirement account will trigger immediate taxes. So we never want to do that. No way to avoid taxes on the retirement account. They want their pound of flesh. They gave us a little bit of a break as we went along, but after 72 and a half, when we're taking the required minimum distributions, part of that is deferred income tax. Okay, so with that, if you have questions about any of these issues, you would call the Bayside office, make an appointment for a consultation, bring your existing documents in with you, and we'll start there. We'll review it all, and thank you so much for coming today.